I greet you now, anyway on a day. So, this news, due to the urgency yesterday, I was not able to see the whole news. I just saw that the Nigerian government is persisting on the trial within trial, but the government of Nigeria's evidence was rejected by the judge James Omotosho yesterday. So the court reject the federal government evidence against Nnamdi KANU because the evidence they have is what they did or they carried out the investigation against Nnamdi KANU under duress. So the trial within trial was done yesterday, being Thursday, 29th of May 2025, and then Nnamdi KANU win again. So I will read out the Abuja division of the Federal High Court on Thursday rejected the evidence sought to be tendered by the federal government of Nigeria in the ongoing trial of Nnamdi KANU, leader of the proscribed indigenous people of Biafra. They keep using this proscription. Justice James Omotosho, in a ruling, agreed with the argument of the defense counsel, Paul Erokoro-san, that the Supreme Court had ruled that in extracting an extrajudicial statement from a suspect, the presence of his lawyer is mandatory. Mr. Omotosho held this thought a provision of the Administration of Criminal Justice Act SCJA 2050 used the word may to mean that the presence of a lawyer to a suspect is not a must. While making a statement, he could not close his eyes to the apex court's decision. Court stood down the matter to deliver a ruling on the admissibility of the evidence sought to be tendered by the federal government of Nigeria. The development occurred after federal government counsel Suraji Saida San and Mr. KANU's lawyer Paul Erokoro San adopted their written addresses and argued their case and against the property of the evidence. Ruling after the trial, within trial, Mr. Omotosho held that the issue is whether with regard to the evidence placed before the court, the statement of Mr. KANU were admissible in law. He stated that the burden of proof in a trial within trial lies with the prosecution to prove its case. The judge said in the mind of the court, the defendant did not establish the allegation of involuntarily in any way. He said that the video recording showed that Mr. KANU were relaxed when he was interviewed by the State Security Services, DSS operative. He said that the video and the statement showed they were the same. However, the statement said the court must not close its eye to the fact that Mr. KANU repeatedly said in the video that his statement were taken without his lawyer. He held that relevant law states that under Section 17.2 of ACJA, the statement of a defendant may be taken in the presence of a legal practitioner of his choice, or where he has no counsel, an official of the legal aid council shall be present. Mr. Omotosho, however, added that a Supreme Court had ruled several times that the presence of a lawyer for a defendant when he is making his confessional statement is mandatory, and the security agencies must comply with it. He said the charge against Mr. Kanu was a grievous one, requiring the presence of the suspect's lawyer during the recording of the statement. The statements are inadmissible in light of the omission of the prosecution, Mr. Omotosho said. He held that the 2015 statement obtained from Mazi Kanu are inadmissible in law due to the absence of his lawyer. The judge subsequently expunged the video evidence and the statement obtained from Mr. Kanu on this ground. The objection of the defendant's counsel is upheld. The statement of October 23, 2015 and the November 2015 earlier admitted evidence are rejected. The judge said Mr. Omotosho proceeded to mark the statement rejected, also expunged from the court's record the video recording of the interview and the statement written sessions that Mr. Kanu had with the DSS officials in October 2015. The video recording were earlier admitted in evidence by the court during Wednesday's proceeding and marked as Exhibit PWO and the PWR, PWQ and PWR. Mr. Omotosho on Wednesday ordered the trial within trial following Mr. Kanu's rejection of the extrajudicial statement sought to be tendered by the prosecution. The IPOB leader had alleged that he made the statement under duress. Mr. Kanu alleged that SSS officials who interrogated him denied him access to his lawyer, threatened not to allow him on bail, and they deny him the 1 hour granted to him daily to receive fresh air, given his health challenge. Mr. Omotosho, he said he was threatened by SSS, that is DSS investigator, whom he described as Brown Okaba, an assistant director of investigation. Mr. Kanu also alleged that his interrogator asked him to say things about the former President Jonathan and the former Governor Rochas Okrocha of Imo. He said he was kept in an underground cell and the video recording played in court were edited. The federal government witness and SSS operative, however, insisted that Kanu was never subject to coercion and that all the complaints he raised were addressed. He denied that Mr. Kanu was subject to any form of duress or coercion, and faulted his lawyer's claim that he was kept in solitary confinement in an underground cell and that he suffered from any ill treatment. The SSS operative said Mr. Kanu was given preferential treatment and served bottled water during the interview session. He also denied that anyone asked Mr. Kanu to say things about Mazi Mrs. Jonathan and Okorosha, adding that the IPOB leader spoke voluntarily and truthfully in the interview. Mr. Omotosho then ordered the conduct of the trial within trial to ascertain the voluntarily or otherwise of Mr. Kanu's statements. Now, in all this, why I am happy that the trial within trial has been taking place and taken care of, and then Nnamdi KANU in victory. Thank you. The comment is there. Thank you.